Thank you both. Turning to the Teamsters Canada, Mr. Benson and Mr. Lacoste. Welcome.
Thank you. Good morning, and thank you for the invitation to appear before you on Bill C-86. My name is Phil Benson, Lobbyist, Teamsters Canada, and with me is Stéphane Lacoste, General Counsel, Teamsters Canada. Teamsters Canada is the, is the largest private sector union representing workers in the federal jurisdiction, air, rail, road, bus, couriers, and more. I will be briefly addressing the proposed amendments to Part 3 of the Canada Labour Code, and Maitre Lacoste will discuss the Pay Equity Act. Teamsters Canada supports the Canadian Labour Congress presentation, and our written submission will follow. The proposed amendments to the Canada Labour Code were a long time coming, and we congratulate the government in moving forward. It is a step in the right direction. The most important change for Teamsters Canada is dealing with contract flipping. The new Section 189 will reduce the ability of companies presenting low bids on federal contracts based on reducing workers' benefits and entitlements under the Code, rather than bringing their managerial expertise to improve efficiencies. The proposed changes will not fully address the problems faced by unionized workers at airports, where contract flipping affects bargaining rights, compensation, and terms and conditions of employment. Teamsters Canada was very pleased when Minister Hadju announced the government will move forward with regulations under Part 1 of the Code to address this problem. Teamsters Canada will participate in all consultations on the regulations, and we encourage the government to move quickly in bringing them forward. Misclassification of employees by employers removes workers from the protection of the Code and also creates an uneven playing field for companies. The prohibition and reverse onus on employers provided by Section 167(1) will enhance existing legislation jurisprudence. This is an issue especially important in trucking, and Teamsters Canada welcomes the change. Section 173(01) provides some scheduling protection for non-union workers. It is not applicable to unionized workers, and even if it were, it would not be applicable to unionized workers falling under Transport Canada power to regulate hours of service in air, rail, and road. Fatigue is both a public and a health and safety issue for workers. The Transportation Safety Board placed fatigue in the transportation watch list. Teamster Canada demands that all workers in federal jurisdiction enjoy the full protection of the Canada Labour Code, and the Department of Labour fulfills its mandate to protect transportation workers. Transportation workers work long hours, and a major irritant is when a workday is extended, forcing them to work instead of attending family responsibilities, a common practice for couriers. Notwithstanding the limitations, Section 174(1), right to refuse overtime to carry out family responsibility, is progressive and shows the government understands the pressures placed on workers. Further evidence of this are the sections 181, see page 452 of the bill, dealing with breaks for medical reasons and nursing.
Bonjour, je traiterai quant à moi de...
Good morning. I'll be dealing with the Pay Equity Act. It was high time for Parliament to pass a proactive pay equity law. We welcome the government's desire to correct the discrimination suffered by women workers. We also agree with the position of the Canadian Labour Congress and make ours their representations. We must insist on 2 points, though. In a decision rendered on May 10th, Quebec Attorney General versus Alliance of Professional and Technical Personnel in Health and Social Services, Justice Abella, writing for the majority of the Supreme Court of Canada, recalled that the very premise underlying pay equity legislation is that women have suffered discrimination in the way they are compensated in the workforce. This observation is well reflected in Section 2 of the Act, but there's also a passage that has no place in a statement of principle such as this one. Teamsters Canada believes that the phrase, while accommodating the diverse needs of employers, is fundamentally at odds with the true objectives of the law and even contrary to the Canadian Charter. The bill must be amended to remove this passage. The bill must also take advantage of Quebec's experience with proactive pay equity legislation. And this has been in effect since 2001. We believe that it would be preferable for the bill to impose a similar obligation to that contained in Section 15 of the Quebec Act, namely, according to Quebec legislation, the employer, the certified association, or a member of a pay equity committee shall not, in establishing the pay equity plan, act in bad faith or in an arbitrary or discriminating manner, or be grossly negligent of the employees of the enterprise. We feel that these that the government should include these points to avoid problems. These two amendments would make it possible to avoid endless litigation and achieve the true objective of the Pay Equity Act. Teamsters Canada will continue to monitor developments and work with the minister to improve the situation of women workers throughout Canada. Thank you very much.
United